panel?
Short comment.
Okay. The 1982 U.S. guidelines, U.S. merger guidelines, had one footnote saying mergers can have non-price effects. A dozen times in the text it said mergers can have price effects. One footnote in 1982, mergers can have non-price effects. So I ask you, now the 2010 guidelines talk about innovation. Now in terms of emphasis, what the enforcers are going to look at, what bias do you think having it all confined to a footnote in the old guidelines and have it in the new guidelines in the text is going to make a difference? And this maybe is responding to what you said earlier. Is it new, or is it just a better way to articulate what we've been doing or what we should have been doing all along? A good economist would say, when I say price, I mean service and quality and so on. But that's not the way we simple lawyers look at things. We simple lawyers say, well, it says price, price, price. And you don't mention non-price, and then you economists say, but wait a minute, you really should take, we're agreeing with you. If you do your job right as an economist, there shouldn't be a difference. But all too often as a practical matter, as in the 1982 U.S. merger guidelines, the text says price, price, price. And then there's a little footnote that says non-price can count. And you, the good economist, would go into the footnote and run with it. How many people would do that?
Lots. Any other comment or suggestion? Yes.
I can give a concrete example to sort of illustrate the point that Bob Land was just making. There's a period of about 10 years when there were 6 or 8 or 10 district court cases involving hospital mergers in the United States. And in a hospital merger, you have to balance pro-competitive and anti-competitive effects. The merger allows you to have certain kinds of specialization and efficiency, and that's good. It also enables the hospital to charge higher rates to the insurance companies it sells its services to, and that's bad. And in a run of 10 years worth of cases, in every single one of the cases, the courts balanced the efficiencies against the higher prices that the hospitals could charge. What the courts never looked at were a different factor, and that is half of a hospital's business is taking in older patients or poorer patients whose costs of care are reimbursed by the government at fixed rates. So there are no price effects on that class of patient. But there's non-price competition among the hospitals for the doctors and the patients to bring the patients to one hospital rather than another. And in theory, the loss of that non-price competition should have been put in the balance also to weigh against the efficiencies. And it never was. And I think that's a good example of how non-price competition can be lost from the picture. And the choice model isn't doing anything that a really good analyst couldn't have done all along, but it's encouraging the analysis to go in the right direction.
Thank you very much. There are 2 more comments or requests, and we'll stop there.
Hi, my name is Frédéric Pelouse. I'm a lawyer and I represent Open Conso, which is a new consumer organization that's going to be launched in France in the next weeks. And I'd like to make a comment with regard to what Thomas Roche said. First of all, I would say that I agree with your statement. The convergence is not feasible. And I would add one more thing. I'm frankly a bit surprised that you did not pick up one of the major differences between the US and the EU, which is with regard to consumer redress. There's one critical difference between you guys and us. It's with regard to the remedy. We do not allow consumer to seek remedy before the court. And this is, do you know why? Because we believe that the state, by the way of restrictions, regulations, do protect better the consumer than an a posteriori redress by going before the court. I know the European Commission is working on this, the class action The Amsterdam Court is paving the way for this by the recent decision that they took with regard to a cartel decisions. And we, as a consumer organization, we will work hard and fight to have the class action. But that would be interesting to know what do you think of this difference and how does this impact consumer choice? Thank you.
We're going to take the last comment and then we'll revert to the...
Thank you, Professor Ginny. My name is Alec Burnside. I'm a practitioner here. I thought, Mr. Everett, your comments on the institutional design, and Professor Ginny, you supported it afterwards, your comments were absolutely spot on. I struggled in the early part of the day, as you yourself indicated, to find where really the difference of substance was on these issues. I think that consumer choice is at the heart of antitrust, but it really is in the institutional design. And I share your regret that the Office of Fair Trading is about to separate those two functions, with the head of the OFT, John Fingleton, at the moment having been such an effective champion for both at the same time. It's a hugely retrograde step. It's also an institutional fault for the European Commission that those two functions are entirely separate. And I think the Commission's lack of success, DG Competition's lack of success to connect with consumers would be greatly redressed if, exactly as you say, it had some of the vocabulary of consumer, the rhetoric of consumer protection to wheel out. Switching topics altogether, Mr. Roche, I have only the slightest knowledge from the newspapers last week of the Microsoft decision on switching off cookies as I read it. Personally, and I don't know the debate that you refer to or what your chairman said, personally I thought it was a terrific announcement because it gave me as a consumer the chance to choose a browser where I would have an instant privacy protection. And that, I think, is a good example of non-price competition, a qualitative element of competition being offered where there wasn't before.
Okay, we're going to give the floor to Tom Roche to answer the two last comments, and then we're going to close.
Okay, let me first of all answer Neil. Okay, I think one of the reasons that we're not seeing more emphasis on non-price considerations in hospital cases is because price is so much easier to measure. I hate to say it, but that's the fact of the matter. Secondly, with respect to the absence of a private regime in Europe, I practiced law for 40 years, 40 plus years in the United States, and I'm here to tell you that we had some real abuses of class actions in the United States, starting with the opt-in or opt-out transaction. At the end of the day, that's what it all boils down to. It's all whether or not you're going to allow people to opt out or they're going to require them to opt in. Now, the arguments in favor of the current system are that it attracts plaintiffs' lawyers as investors, which is a real plus. There's no question about that, because without these folks as investors, they probably would not bring these cases. Second, however, there are two countervailing facts that I see at work here. The first is treble damages. Are you going to allow treble damages? Well, you don't need to allow treble damages. If you allow prejudgment interest, it ends up equaling or exceeding the amount of treble damages anyway. So it will attract investors, or it should attract investors. Secondly, more important than that, is what has happened to our Supreme Court in the last 10 years in terms of the jurisprudence, antitrust jurisprudence. Because our Supreme Court has been very concerned about the private class action bar. The problem is that public enforcers enforce the same antitrust laws. So what the Supreme Court holds that the private antitrust bar has to put up with goes for us as well. So I see that as really a huge problem.
Thank you very much. We did leave the previous panels with the idea that maybe choice or consumer choice was not really a new standard for antitrust. But this panel has added clearly a dimension to this. The first dimension is, I must say that I think that Paul was asking originally whether this new standard could lead to convergence. Okay, well, it's not a new standard, and convergence is out of the picture as well for reasons which have been explained. But it is quite useful. And it is quite useful because irrespective of what the economists have said, the fact that they are also concerned with non-price restraints, it's not always true in the analysis that they devote as much attention, or maybe it's too difficult for them to do it, but still there's a need there. And clearly what this discussion allows us to do is to go deeper into the analysis of how competition eventually works. And by remarking there are two parts to it, the opportunity and then the fact that the consumers take the opportunities. And that's where behavioral economics, by the way, becomes tremendously useful, because it does point to a number of issues on how people actually exercise their choices, and makes the link with not only competition, but also competition law enforcement and what would be needed. I think that there is a consideration, aside from our learned discussion this afternoon, which also brings this to the fore, which has been the massive failure of 2008, sorry, in the real estate market in the US, which has shown that you can have entire markets where behaviors are outside what one would call rational, both on the supply side and on the demand side. So that brings to the fore a line of work done by behavioral economics, which could be used very much to promote this choice approach as a complement or as a way to make competition and consumer protection more complementary. As we've said, this has some institutional implications. I've mentioned one already about the UK. I would like to mention another one. I have been the chair of the OECD Competition Committee since 1994. In the Competition Committee of OECD, there are about half of the agencies, and that's about 17 or 18, which have responsibilities both in consumer protection and in competition. There's another committee at OECD, which is the Consumer Committee, where pretty much the same agencies sit. I have been able to organize one meeting in nearly 19 years before those two committees. Half of the members coming from the same agency. They just didn't talk to each other. One of the things that this debate today has achieved, it has allowed us to really look at those issues in a way which I must say was much deeper than this one meeting that took place at OECD, where we negotiated which cases we're going to look at. Ended up thinking that the funeral industry was an appropriate place to look for both consumer detriment and competition detriment, but never went to the depth of analysis which I've seen this afternoon. So I want to thank all the speakers that we've had, and also thank you all for being with us and participating in this debate. Thank you very much. Paul, thank you very much for organizing this.